Today is March 16th, 2022. My name is Rob Carr of Kalamazoo Right to Life, and this is Pro-Life Week. Well, here we are. It is a new week, and we are 1 week closer to the Supreme Court's announcement on the Dobbs decision. And we're trusting and praying that the court will make the right decision and either overturn Roe v. Wade entirely, which would be the ultimate victory, or at least uphold the Mississippi's 15-week abortion ban, which would strike down the whole issue of fetal viability that has been the cornerstone of the Roe v. Wade decision. It's basically saying that until fetal viability, states cannot enact legislation to restrict abortion. Well, obviously, 15 weeks is before viability. So we'll see how it develops, but we are getting closer by the week to that decision. But today, I do want to mention a few other items that are in the news this past week. And on Monday, the Idaho legislature passed a heartbeat bill very similar to the one enacted in Texas. And the vote was a very strong pro-life vote, 28-6 in the state Senate and 51-14 in the state House. And you know, I'm reminded when I see those lopsided figures, 51-14, 28-6. When I see these lopsided numbers, I'm reminded by what I hear from the other side. All the time I hear the same thing, that Roe v. Wade is settled law. The Supreme Court has decided that abortion is a constitutionally protected right, and that we're just being crazy by thinking that we can enact laws to restrict it and ban abortions because abortion is settled law. Well, let's face it. We know that there are millions and millions and millions of pro-life people in this country and many, many pro-life lawmakers in various state legislatures around the country who oppose abortion morally, ethically, by their faith beliefs, because of different interpretations in law. And they're passing laws by the hundreds to restrict abortion because abortion kills children. That's what it does. It's murder. It is murder on the unborn. And, I'm reminded, too, of what Justice Amy Coney Barrett said when she was before the Senate Judiciary Committee in her confirmation hearings. She was asked if Roe v. Wade was a super precedent. And she said, no, it wasn't, because calls for its overturning have never ceased. And, what did she mean by a super precedent? Well, she described one as the Brown versus Board of Education. No one today favors a return for segregation in the South, to segregate schools again. Nobody is calling for that. Nobody is calling for that. But with abortion, with Roe v. Wade, calls for its overturning have never ceased. Since day one, there have been calls to reverse that decision. From day one. So is Roe v. Wade federal law? I don't think so. Okay. Yesterday, the South Carolina Attorney General filed an amicus brief in a case called Planned Parenthood South Atlantic versus Wilson. Case centers on South Carolina's 1-year-old fetal heartbeat law. And it was passed in February of 2021, blocked by a federal district court about a month later, and that was challenged, repealed, and then it was decided by the Court of Appeals of the Fourth Circuit that upheld the district court's decision and declared that the law was unconstitutional. Well, 21 states' attorneys general from around the country have joined the South Carolina Attorney General in this amicus brief. And let me just give you a rundown on these 21 states. Alaska, Arizona, Arkansas, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, North Dakota, Ohio, Oklahoma, Tennessee, Texas, Utah, and West Virginia. Well, you may have noticed that missing on that list is the state of Michigan, because we are governed by a radical, ideologically driven Attorney General who hates our guts when it comes to abortion. She is ideologically driven. She is a pro-abortion zealot. So she's not with this case at all. Similar to other heartbeat laws, the South Carolina law requires abortion providers to give a mother an opportunity to have an ultrasound and to view the sonogram, to hear the fetal heartbeat, and to receive more information about her unborn child. And here's the rub in this amicus brief, because it focuses on the education requirements, not on the actual detection of a fetal heartbeat. So I'm going to read a little bit from the brief, just a little bit. Quote, states have an unquestioned interest in making information about a child available to a mother who is considering abortion. That is why Planned Parenthood and the other plaintiffs challenged only the law's regulation of abortion after a fetal heartbeat is detected. However, the Federal Appeals Court ruling affirmed the errors of the lower court by enjoining the law in its entirety. Now that's important, it's in its entirety, blocking the law's many disclosure and education requirements, which are legal and enforced in many other states, including Alabama. Let me continue. At least 24 states currently require an abortion provider to offer to display the image from an ultrasound so the pregnant mother can view it. She's not required to view it, but she has the opportunity to. 16 other states make the fetal heartbeat audible for the pregnant mother. 12 other states require that an ultrasound be performed prior to an abortion. And written into the text of the law, it says, if any part of the law were held unconstitutional, then the remainder would not be invalidated. So the law, the amicus brief is basically saying that in these other areas, you've blocked the actual 6-week abortion ban from the fetal detection, but you've also blocked the other aspects of that law that have been upheld by many other state or federal courts, including having the opportunity of seeing the ultrasound, the opportunity of hearing a fetal heartbeat, and the sonogram. So we'll see what the Fourth Circuit does with this amicus brief, because it does perhaps reopen the whole argument on perhaps blocking part of that law, but not all of it. Okay. So yesterday, another thing from yesterday, the pro-life governor of Wyoming signed a bill stating that if Roe v. Wade is overturned in the Dobbs case, that abortions will be banned in the state of Wyoming, with exceptions for the life of the mother, for rape, and for incest. So I also read that if Roe's overturned, 26 states may possibly be listed that would ban abortions, including Michigan, which brings me to another issue. And as we know, Planned Parenthood and the ACLU and a few other pro-abortion organizations have launched a petition drive to place on the a ballot proposal that would be a constitutional change that would repeal our 1846 law and make abortion legal up until fetal viability, which is, like I've mentioned before, to me, fetal viability is an arbitrary benchmark. It's not a benchmark. It's a moving target, because medical science is saving babies at younger and younger gestational ages. So a 24-week viability is no longer medically sound science at all. Anyway, I digress. So this petition has been launched, and just a few weeks ago, Right to Life in Michigan and the Michigan Catholic Conference and some smaller pro-family and pro-life organizations have formed their own coalition called Citizens to Support Michigan Women and Children. They've been formed to defeat this petition drive and or this ballot proposal in November. And we will need lots and lots of money, millions of dollars, to wage a successful and effective media campaign to educate the voters of what this petition drive really says and what will change if that law takes effect. Detrimental things, not just to our 1846 law, but all the laws that we have passed or enacted in the last 35, 40 years will be thrown out the window if this thing is passed by the Michigan voters. So, and now there's a good thing, and that is the way the petition is worded. It basically says, do you support change in the Michigan Constitution to uphold abortion rights? And the pro-abortion response would be, yes, I support the change. So the pro-abortion people have the yes vote if it goes to a ballot in November. So we have the no vote. We would oppose that change in the Michigan Constitution. And studies have shown that very often the no vote is more effective with voters. And ballot proposals are rejected more frequently for those who have the no vote. So we have the no vote, no on changes to our 1846 law. With that, I'll let you go. See you next time.